very good morning to all of you, and glad that you all made it on time. Our first speaker, and I suppose you already know what the general theme of the morning will be, which is to have these conversations with practitioners like Dinesh on their specific experience in mediation in the real world. I know that you've spent the last 2 days doing mock sessions, but this is what happens in the real world, and we are very glad that you can make it today, this morning. And Dinesh has already been introduced with having more than 2 decades of practice experience. And I did look at your profile as well. It talks about how your peers have spoken of your strategy and implementation of strategy as one of the things that they really look at, something that you do really well. I also noted that you act as an arbitrator, which is something that I do want to ask a couple of things about, and perhaps scratch your mind about that particular aspect as well. But to begin with, I know of you as being somebody in the construction world, doing a lot of construction work, and which majorly involves arbitrations as the most preferred method of solving those disputes. And as you would see, an arbitration goes with a certain track, which has kind of a lot of certainty involved in it, in the sense if you jump that train, if you're on that train, you know that it's going to end up at a destination. Of course, there will be delays and there will be issues, but there will be an outcome at the end of it. So you go through the motions, you know that at the end of it, you will arrive at a destination where either you lose or you win, but there's certainty involved in it. With that in mind, where do you think mediation fits as against arbitration, or in comparison to arbitration, as an effective tool in your practice experience?
Good morning, everyone. Thank you, Gracious, for your kind introduction. So when a matter comes to us, we assess, because in our view, not every dispute has to go to court or arbitration. There are other means of resolution. So we seriously look at mediation as well, because if your client's case is weak, then you have to suggest mediation to them, because to my mind, while arbitration does not bring certainty, because even if you win or lose, there are those 34s and 37s in Supreme Court enforcement, which does not bring certainty, but mediation does. So we of course think about mediation. Now, whether we are acting for respondent or claimant, mediation will be considered. Timing of mediation is something that we will, for a claimant, maybe decide upfront, or maybe after filing of pleadings, or after completion of pleadings by both sides, because then respondent knows where your case is. If your case is stronger, and if it is before for an arbitrator, you know that, look, the respondent understands that you have a good case. And especially in international arbitrations, you will always explore mediation, because if you have a good case, you'll be able to achieve what you want to achieve in terms of recovery or declaration. So we do consider, and I think mediation brings what arbitration can never bring, which is time and cost efficiency and certainty. You get your money, you move on, you can carry on the relationship with the counterparty, which in arbitration you may or may not. So it is something that is an integral part of any dispute resolution for us. Now, I'll give you an example how it works in other countries. So we filed a case against a Chinese company. After completion of pleadings, we commenced mediation. The benefit of mediation in other countries is that within 15 days, mediator was appointed. Within 30 days, a hearing took place for mediation. Believe me, we sat at 9:30. 2 a.m. next day morning, we signed the settlement agreement. Now, in 1 day, we were able to achieve what arbitration could not have obviously achieved in next 2 years. But why it all happened? It all happened because the mediator was aware of the facts. The mediator had read the file. Mediator, in fact, had asked us to get authorization in case settlement agreement has to be signed. So that was a seriousness involved in mediation. So just to answer your question, mediation is an integral part, and we do consider in every dispute that we come across.
Right. Since in the example that you mentioned, I see that there is an additional layer of the internationality involved in it. I suppose in a case where the choice of forum is abroad, either by way of a court or an arbitral seat, and I suppose a foreign party involved, in all these considerations that get added to, let's say, a dispute that you're handling, are you suggesting that mediation is more of an effective option as compared to arbitration as you would look at it?
No, I think it all depends upon each case. Every dispute cannot be resolved through mediation, but an attempt is required. And it is more effective maybe overseas because of cost implications that you have to suffer in case you lose a matter, or the cost that you incur for any arbitration. So that is the driving force for them, that look, let's be clear, certain about it, whether we want to fight or not, because the cost implications are much. And then because the cost is also heavier at the time of enforcement or challenge, it's the driving force for them to sit on the table and settle it. So I think those are the different scenarios in India and outside. Like in India, you don't have cost repercussions in case mediation fails. But an arbitral tribunal, in case mediation fails, depending upon the outcome, will consider that, look, whether a party did not go for mediation or did not honor mediation. So all those considerations will also be considered cost implication, which is not the case here.
And if you don't mind, would you be able to share some bit of the process as to what was the nature of that particular dispute, and how did you how you went about it in arriving at, you mentioned that you were able to finish all of this in one day. Could you give us some information about how you went about it? What was the driving force at that point for your client or for the opposite party as to both of you coming to this agreement to let's mediate this out?
Okay.
And then proceeding forward on that.
Sure, Gracious. I think more than facts, what would be important is the process for mediation. So obviously, if you ask any client, unless there are ego issues involved, they're happy to resolve. They want to concentrate on business. So therefore, they're happy either receiving money, even if less than what their expectation is, but receiving money today is much better than after 3, 4, 5 years. And even for a defendant or a respondent, he would want to get off his chest, because he also wants to focus on business. But I think the process that was involved in the international couple of mediations that we have done is that the mediator was aware of the facts. He had read the file cover to cover, so he was aware what is claimant's cases, what is respondents. So obviously he gave opportunity to both sides through counsels to make presentation. After that, separately for both the counsels. Third round, when he realized that, look, counsels are not helpful, let me take the authorized representatives of both the companies separately. That was the third layer. Fourth, separately with them to tell them that, look, this is what your case is, this is what you are going to lose, or this is what you're going to get, why don't you accept little lesser? And then that's where gave time to both of them. They realized that what are they getting into, inform them about the business that you can continue. Both of them required each other. So there were multiple layers. And why it was possible? Because mediator had the intent to do. It was ensured that the authorized representatives carry the powers to sign a settlement agreement. So the intent is all there. Okay? And then the framework. When you go for a mediation, the arbitration file automatically comes to the mediation center. When you sign a settlement agreement, the file automatically goes to the arbitration center. The award is made on the basis of your mediation, and then award is made so that mediation settlement also becomes binding like an award. So that's a process. That's a seamless framework provided by these countries so that it becomes an enforceable thing, which is still missing, and of course we are trying. But that is the process that brings efficiency in the system for mediation.
Yeah. Can we now transpose to maybe one of your domestic experiences that you may have had in the mediation, and perhaps couple that with where you thought, would be factors of improving the mediation ecosystem here based on the experience that you've had domestically?
So you can blame me also as a counsel to not let mediation happen or be successful. But obviously there are instructions from clients that, look, we don't want to settle like this. Let him suffer and we'll see in arbitration, we'll pay the money after 4 years. So that's the mindset sometimes you come with these clients. And secondly, because I'll be honest, when mediation comes, obviously you're not read the entire file, you're not aware of the entire facts. You're going with whatever limited information you have, what client has given you. And when you go to the mediator also, barring few mediators who are still serious about it, they have not read the file. They're just hearing from half-baked information that you have, half-baked information the other side has, and will make a half-hearted attempt because obviously he's not aware of the facts. And of course, because training is missing, you can't tell the other side or the claimant or respondent that, look, this is what you're going to lose. So all that half-baked attempts, sometimes you don't get results out of them. So I think that is what is missing. And it's not that mediation is not happening effectively. We have seen mediation which is happening effectively. And I think it is working more in matrimonial matters because of different considerations. But when it comes to commercial, the success rate is still much less, because the cost implications are not there on the parties. When you are mediating with government obviously is always skeptical about signing a document. Who will sign a document which says that, look, money has to be paid to a private party? So all those considerations are making it still difficult for India to have that successful regime for mediation like we have in other countries.
I know what you mean, in the sense, when mediation usually happens right at the initial phases, even as a counsel, you haven't really done a thorough job of knowing the entire file. Because this is something that you do only when you are gearing up for an arbitration, preparing a statement of claim. You've gone through the documents, you've analyzed what your claims are, what's the quantums involved. But in mediation, I suppose that's where I think there's the need for a mediation advocate sort of a role to play over there. I know that when you enter into a mediation, you have to know what this is going to look like all the way at the end if we were to take a different route. And that involves a whole lot of preparation right at the initial stages, which sometimes may not be all that feasible, but absolutely necessary. Because without which, to trigger a certain conversation, even in a mediation, or to sort of give an effective information to the mediator, which can be a helpful way of negotiating with the opposite side, may not be so viable. So yeah, I think the early preparation, both from the counsels and from the mediator, is a huge factor, considering that. Any other thoughts? And we may even take a couple of questions if you have any. But any other thoughts on...
Just to add, like we say that every dispute requires a strategy. To my mind, mediation requires strategy as well.
Right.
When I'm talking about these international mediations, even at the beginning, we decide when we want to go for mediation. As a claimant, I would say that, look, maybe because my case is stronger, I will go after pleadings are complete because everyone knows what my case is. So that strategy plays an important role. Even when you're sitting in a mediation meeting, you have to think about how do you want to implement your plan. This is your plan A, plan B, plan C, or you don't have a plan B, plan C. So it's also a sort of a strategy that you have to implement. And secondly, I think it should be taken as seriously as arbitration hearing. You don't have to keep the mediation for 1 hour, 2 hours. Keep the mediation for the entire day, as if everyone in the room is, the idea is to get it settled by end of the day. If you go with that intent and the mediator is prepared, I'm sure the chances of success will be much more.
I understand the situation. That's perhaps in a case where you've entered arbitration and that's the only, let's say, agreed dispute resolution mechanism. I would say that that strategy would be helpful to decide right at the early stage when is a good time for us to mediate. But in a case where you already have your pre-arbitration amicable procedures, negotiation, mediation, and often counsels don't really get involved during those phases at all, I suppose. And even if they do, I suppose this particular element of being absolutely prepared to make an effective representation would become necessary.
I agree.
Interestingly, I mean, this is just a thought. I suppose that's why some of these contracts that are there in the market, they prefer starting with a DAB before an amicable resolution. They start with a DAB or a dispute adjudication board, then move on to amicable settlement, and then arbitration. I suppose that early round of some amount of discussion on the merits is a helpful factor. And it's something that only strikes me now when I'm having this conversation, actually. So
DAB works in other countries, but not in India.
yeah, I suppose in
So-
the effectiveness of it, but for the process, helping that for parties to come to understand their merits, at least in some adjudicatory setup, is helpful to then take it to amicable settlement and try and see if there's a resolution possible amicably before going to a full-blown arbitration, I suppose.
Maybe adding that step to achieve that objective is very cost
Correct. Intense.
and intense and time consuming. So I believe instead of that time period, you prepare and then go for mediation is a more effective remedy for us.